confusion. Morning, my lord.
Yes,
my
Mr.
lady.
O'Neill.
So I appear together with Ms. Hafsa Massoud for the appellants, or the defendants as we've referred to ourselves in the skeleton argument, just to try and minimise confusion. My learned friend Ms. Sonali Knight QC appears with Ms. Savage and Ms. Fitzsimmons for S, and Ms. Savage appears with Mr. Spellwood and Ms. Sardar for AZ. You'll have seen our skeleton argument also named Mr. Brown of Queen's Counsel, who sent his apologies. He's travelling today and was unable to be here. So you just have...
Yeah, well, I'm sure you're very well supported anyway. Yes, now, the first question, you may have things you want to deal with first, but the first substantive question is this appeal academic?
That's absolutely right. I was going to just deal very briefly with bundles.
Yes.
Just to make sure we've all got the same bundles and there's nothing missing. Then my submissions were going to adopt the following scheme. Firstly is the appeal academic, and if so, how should the court proceed? And then if the court was going to proceed, I was then going to address the scheme for applying for leave to enter within the rules, outside the rules, the specific context of Afghanistan, these cases, and the judge's reasoning, and I thought we'd be in good time for the time estimate. It's quite a narrow point.
It is quite a narrow point, and we've done our reading. I don't want to criticise anyone because this appeal has had to be prepared in haste, but there's still quite a lot factually we just don't understand. I can't think why it wasn't thought appropriate for us to have from the start the full correspondence.
No.
But that was helpfully supplied, only even now it's incomplete. There are some letters referred to which we haven't got. I don't know why.
Yes.
They may in the end not turn out to be important, but we may just have to pause for time and from time to time and just work out actually what facts are. We do want to understand the detail. And the other problem is we don't know what any of these forms look like. Everyone's talking about the form this, form that, and the bots for this and bots for that. We haven't got any of them.
No.
And we still haven't got any of them.
No. Can I start with a sincere apology for this? By way of explanation rather than excuse, firstly, Ms. Massoud and I both fell ill with COVID and so weren't around at all to support our instructing solicitors at the time they were trying to pull the bundles and things together.
No, well, that is an excuse up to a point, and Mr. Brown isn't here. You can blame him. Is absent or tout autour.
He was dealing with the case of KBL that had been adjourned at this hearing and which was also listed for hearing at the time that Ms. Massoud and I were both off sick.
Yes, okay.
So it was a very difficult time for the Secretary of State's team. But the other point that I realised as I came to prepare this case was that although this is the sole issue before this court, it was one issue amongst a plethora at first instance.
We did spot that. There was an awful lot of emphasis on the points on which the claimants lost, essentially, could they claim under ARAP.
Yes. And there were also a number of points which ended up not proceeding, but to which a lot of time and documentation had been devoted. So the martial evidence, parliamentary privilege, we had the Office of the Speaker.
We have seen all that, and I didn't mean to get diverted into I had to get it off my chest. You have apologised, and that's, I think, good enough for us.
Well, I'm very grateful.
But it does mean that there will be points where we've got to say, well, can you explain about this, because it isn't clear from what we've got.
Yes.
But I'm sure you will be in a position to do so. Yes. Right, now.
Just on the bundles, could I just check? I've got an electronic copy of a clip of additional material. I don't think I've got a hard copy. I'm just trying to establish, I'm not trying to criticise, I'm trying to establish whether or not it's only in electronic form, or whether it's been lodged in hard copy and it's gone astray, or...
I think it may have gone astray because I asked for a hard copy and I've got one. I think we had asked, it has been lodged. So when?
But don't worry, I've got it electronically.
Yes, I in my case, it hadn't arrived when I wanted to read it. in hard copy, so I got my clerk to print it out. It's only 100 pages.
Yes.
But I was told a hard copy was expected. But anyway, there we
We'll
are.
make some inquiries. A hard copy was produced, and I'm so sorry if it hasn't reached my lord. There was something else I was going to say about forms in particular.
Yes.
So, albeit in response to my Lord Justice Underhill's prompt, some work was done to try to put together blank visa application forms. And I had forgotten that, in fact, we tried to do this at the stage of the administrative court, and it proved to be impossible to do in a manageable way because they're electronic forms. So you end up with a sort of family tree where, depending on your answer to the first question,
yes,
you may get one of 4 or 5 different screens. So we ended up with 15 emails, each of which had a number of attachments. We discussed this and just thought the court was not going to be assisted by this plethora.
Okay, I have had this problem before. And can I just say again, it seems to me absolutely astonishing that the Home Office doesn't have paper versions for reference purposes of the forms that are available online. I've been told it doesn't before. I expressed dismay and surprise then. In 99 cases out of 100, 999 cases out of that, they don't need it because you can do everything you need to do online.
Yes.
But from time to time, and court is one example, but there must be others, people will need to have in front of them a blank copy of the form.
Yes.
And I really do not believe that with proper IT resource this couldn't be achieved. And maybe not in a day or two's notice, but knowing this problem has arisen before, you would have thought somebody would have thought about it. And I hope those representatives of the Home Office who are in court today will give some thought to that. This is not going to be the last case in which this court, but I suspect plenty of other people as well, want to see what a form looks like in blank.
Yes. I know my lord's raised it before, and we have pressed that in the last 48 hours, and I know that the message has been sent.
I'm sure people have worked very hard, and I can see it may be very difficult to do at short notice if the system doesn't make it easy.
No.
But with proper IT resource, it can't be impossible.
No.
And somebody should have thought about this earlier.
Sorry, I'll leave it there.
No.
Yes, what we have suggested, and I don't know if this will be helpful, is that somebody just filled in a form the way it was said an applicant ought to fill it in, so you didn't have all the variety of possible screens, and it then be redacted. And I hope
we've got one version of one form that looks like that, but we haven't got all the others.
No.
Anyway, there we are. Let's get on. I'm sorry if we haven't. It's largely my fault, not yours.
Absolutely not. In terms of what we have got, apart from the missing hard copy of the supplemental clip, I hope that the court has a core bundle, a supplementary bundle, a second supplementary bundle, a clip of additional documents, and then a bundle of authorities, which is relatively modest for these sorts of cases, which is a relief, I hope. So I've outlined the scheme of my submissions.
And I should say, we also have 2 versions of everybody's skeleton arguments, an original one and a referenced one. In the case of the claimants, the referenced one includes something called an ARAP eligibility criteria table. I think a formal application has been lodged to have this admitted. Obviously, there hasn't been an opportunity to rule on that application. As tends to happen, I think we better just accept it for the moment, de bene. If it creates any problems for you or if you think it's inaccurate, you can tell us as we go along.
Yes, that's entirely satisfactory from our perspective. We'll deal with this in a bit more detail when we get to ARAP, but from our perspective, or our cases, that it's not the substantive eligibility criteria that matter where ARAP's concerned for the purposes of this one issue before the court. It's the process, the ARAP process. And so I am going to be asking the court de bene essay to look at an ARAP entry clearance stroke visa application form, which isn't before the court, which is, I hope, being provided, again, a redacted one, but just so you can see what happens when it gets to
this is the one that the MOD fills in,
yes,
as it's put, on behalf of the applicant.
Yes.
Well, I think we'd certainly want to see that, yes.
I thought you probably would.
Before we get to that, I've gone to the electronic stuff and I opened up, I think it's page 5, and there's a crest there which looks like the government crest, and it says new application for relocation to the United Kingdom under ARAP, and I thought that must be the form that the person fills out. And although you say the MOD sends things to the government or to the Home Office, I thought, but you'll tell me if I'm wrong, that it's page 5, I think it is, of this bundle that is the form that the person fills out. And then that says, we will contact you, and I wonder to myself, who are the we here? And it seems to be the government or the Home Office, and it seems to talk about the Home Office getting stuff from the Ministry of Defence. So I wonder whether you're not starting in the middle of the process when you say we've got a new form here which you're going to look at. Is this the form that a person would fill out? Is this what the ARAP form that the individual fills out is? And if so, why isn't that a form sent to, in inverted commas, Her Majesty's Government or Her Majesty's Secretary of State to the Home Department?
Well, my lord's come absolutely to the nub of the issue.
Well, I think having flagged
my
lord, having flagged it up, and I agree, it is very important. Shouldn't we deal with the academicness question first? Otherwise, I know what will happen. We'll go. I'm all for going to the nub of it, but if it's not something we're supposed to be dealing with in the first place, we're wasting our time.
I will do my best to take whatever sort of order of submissions is.
Well, I think we must logically deal with the academicness point first. So you've seen what Ms. Knight says in her skeleton argument. What do you say?
Okay, so our response comes in 3 stages. We say, firstly, the appeal is not academic. Secondly, the court's not with us on that and considers that the appeal is academic. This is one of those circumstances where, one of those cases where the circumstances are truly exceptional and the court ought to allow the appeal to proceed without requiring the Secretary of State to indemnify the appellants in respect of their costs. You'll have seen from the appellant's skeleton argument that they accept that they are in a position to fully
we've seen
argue
that,
the
yep.
points. But our third sort of fallback, if the court doesn't accede to either of those submissions, we do have instructions that the Secretary of State is agreeable to indemnifying the respondent's costs of the appeal from the date of the in-principle decisions. And could I say a little bit about the in-principle decisions and just bring the court up to date on the facts?
Yes.
So, in light of the particular circumstances...
We have got them.
Are
they both of the same... No, don't worry. Are they both of the same date? In which case I'll write that down. Sorry?
I'm pretty sure they're the same date. They're in the clip.
Yes.
Either the 22nd or the 26th, I think.
Yes, they're both the 22nd of July and they're ages 40 and 46.
So, I think we just need to write this down in case it becomes firm so that we can put it in our judgment if we proceed. Secretary of State will agree or agrees in this event to indemnify the claimants for their reasonable costs.
Yeah.
From the date of the
in-principle decisions.
In-principle
the 22nd
decisions.
of July.
Just in case I lose sight of that, Ms. Knight, if we get to that being the relevant question, are you content with that as a form of indemnity?
Yes, that's. I've noted.
Thank you very much.
We did ask for that in correspondence, but only yesterday. Thank you.
Right. So it's points 1 and 2. Why isn't it academic?
So, because the decisions that have been made are very clearly expressed to be in-principle decisions, so effectively without prejudice to the Secretary of State's position that there has been no valid application. And that's a very exceptional way for the Secretary of State to proceed. And she has done that on the basis the fact it's been accepted throughout. In the case of S, I'll come to this in a moment, was accepted until last night, that the respondents were at risk from the Taliban and were living in precarious circumstances. In granting permission to appeal, Lady Justice Andrews, it's at pages 38 and 39 of the clip, you will see at paragraph 8 of her reasons, she said this: I share Mrs. Justice Lang's concerns about the impact of the further delay, given the very real risk to the life of the claimants and others with a similar background, which is accepted to exist. I'm acutely conscious of the position of these claimants and the dangers that they face. They've succeeded in their claim for judicial review, and the fact of an appeal by the Secretary of State should not be allowed to create further delay in consideration of their applications for leave outside the rules. Therefore, I have made it a condition of granting permission to appeal that there is no stay on
Yes, sir. Yeah, we
Lang's
saw
order,
that.
and that the applications for LOTR should be progressed, just as they would have been if I had refused permission.
Yes, so in practice, you say the Secretary of State has done it because she's conscious of the risk and so on. That, and we making any cynical point, but the reason she has progressed is because the order of the court required her to.
Well, it's certainly the order required.
It wasn't a mandatory order, but the logic of the court's decision meant that she had to make a decision.
Yes, indeed. To be faithful to the logic of the order, she had to proceed to make a decision. And she did that expressly on the basis that it was an in-principle decision.
Yes, now you glossed that as meaning without prejudice to... Without prejudice to what?
To her position in this appeal, which is that there hasn't been a valid application.
Yes, that's what I thought. Yeah, thank you.
In fact, we have, well, the intervening stage, the reason for doing it in practical terms was so that the respondents could consider their position. If the decisions had been favourable, then they would know. If they didn't succeed on this appeal, they would need to make valid applications pretty promptly to get the benefit of those substantive, positive decisions in their favour. In the event that the decisions were negative, which they were, they would then be in a position to take legal advice and progress any challenge.
So
now,
if we say that the applications were valid, these would then become the substantive decision.
Yes.
Okay.
Yes, absolutely.
Right, sorry.
And if not, if you're with us on the appeal, then the appellants would simply need to put in a
valid application.
valid application.
Hang on 1 second.
In fact,
Just 1 second, sorry. Well, it all depends on what basis the appeal succeeds. If it succeeds, so on the basis if it fails, if we were to say that the ARAP form wasn't the nearest available form, but that what I might call the para 136 point, the point about biometrics, it was valid because you insisted on. You didn't give them the opportunity to apply for biometrics deferral or waiver. The consequences might be rather different, mightn't they?
yes, probably what I should say is they can consider their position depending on this court's judgment and order and the reasoning for it.
Yes.
Just to complete the picture, what the Secretary of State hoped to achieve by making in principle decisions, i.e. progressing the substantive consideration of the merits, has evolved and developed further because last night we received pre-action protocol letters signalling challenges to both of those decisions.
Right.
And they included the information that S is no longer, in fact, in Afghanistan. I don't know if that's come to the court's attention.
No.
So S apparently has been in Pakistan since the 1st of June. So her solicitors only became aware of this at the time that they were preparing the representations which preceded the in principle letter. But because of an oversight with...
Sorry, only became aware... Sorry, I appreciate this is only what you've heard from them, but what date, when do they say they became aware?
They've provided us with a witness statement in support of their pre-action protocol letter. So the 30th of June, Miss Lenny of Wilson's contacted S to take detailed instructions by telephone. In fact, on the 29th of June, she contacted S to arrange an appointment and asked what time would suit her on Kabul time. And S responded to say she was available at any time and mentioned she was in Pakistan.
I see. Thank you. So it became aware on 29 June.
Yes.
Not communicated to Home Office. Ms. Knight will tell me if this is wrong, as they accept they could have done, but it was an oversight.
Yes.
Yeah. Okay.
And just
That's right, Miss. I don't want lots of detail, but
No, my lord, that's correct. The representations were sent. And
no, we're not going to look into any of this, but I just want to understand the position. Yeah.
And can you just remind me where AZ is? Is he in Pakistan? In his...
No, AZ remains in
He's
Afghanistan,
still in
as far as
Afghan
we're
with
aware.
his elderly mother, wife, and 6 children.
Yes, and it's S.
But
who is-
and do we understand S and her family are in Pakistan?
I don't know.
Yes, my lord.
Yes. Thank you. Well, I mean, that makes a huge difference, doesn't it?
Yes, it does. Yeah.
Because unless I've got this wrong, there is a visa application centre in Pakistan. I forget.
Islamabad.
It is Islamabad. She can make an application, assuming subject to the other points, which are not actually points directly in issue, though they may be implicitly in issue, on an appropriate form, and she can now name on that form the visa application centre to which she will go. So that point in her case goes. The other point doesn't.
Well, it doesn't go entirely, does it? Because at the time that she made, or said she made the application, she was in Afghanistan, and she couldn't have completed a form saying, I intend to go to Islamabad and get it done there. So for the validity of the initial application, if there was an application, it doesn't go, I don't think.
It goes for the future, I think.
Yes.
Yes.
And there's actually an intermediate stage as well, because as the court, I hope, will have picked up from Janet Gordon-Smith's witness statement, although back at the end of 2021, you had to tick a box that said, I confirm I can attend this visa application.
Yeah.
The Secretary accepted the forms were defective,
Yeah.
and they were amended. So as of at least April, you were able to tick a box that said,
Yes.
I can attend or I can't attend, and then you were directed to a page that enabled you to inform the Home Office of the reasons why you couldn't attend visa application centre. So there've been
So in a sense, you're quite right. In a sense, your position would be, I'm not sure this would have been accepted. I can't see why not. That particular problem was solved,
yes,
whether you're in Afghanistan or Pakistan.
yes,
Just while we're on that, there's talk about the form was amended. Presumably this means every form was amended,
yes.
i.e. all the forms that appear on the website had the defective box, and on all of them it's now been changed to the correct box.
That's certainly my understanding
Yes.
from Ms Gordon's. Yes, it's visa application forms.
This is Ms Sood's
used to
understanding
have
as well.
this. Yes, used to
Okay.
have this box.
Well, okay, that's...
Can I, because I'm finding it conceptually difficult to understand what happens. So there's a box on the ARAP form and each of the other forms, which you call visa application forms. And if you couldn't complete that box, for that reason alone, irrespective of anything else, if you couldn't complete that box, saying where you're going to have your biometrics, done, you would treat the application as invalid.
Not on the ARAP form.
No.
Right, that's why I put that in, actually.
Well, let's leave the ARAP form out of it.
But
But
on
on the
form-
visa application
On visa
forms
application.
in Home Office parlance,
Yes.
Yeah.
what can we? Well, I'm sorry, it's the second time I've done this to my lord, and I
leave it.
started it. But can we leave it?
Yeah.
Because we all got into this on the question of S being in Pakistan, which is interesting, but is not directly the reason why this is said to be academic.
I'm so sorry, we keep
let's-
segueing into the
no,
merits,
well,
don't we?
it's,
Yes.
we must. I must restrain myself.
My fault, I know.
No, let's go on with that. With why you say it's not academic.
So that is why I say it's not academic, because where the case goes from here, or where the cases go from here, would still turn on the outcome of this court's decision.
Yes, I see. Okay, so that's why it's not academic.
If the court's not with me on that, and considers
Do you take any point on costs? I mean, a cost order was made against you, wasn't it?
Yes.
I haven't looked at all the academic type cases, but the couple I looked at which have been given appear to say by implication that if a lot of costs, or if costs in principle ride on the outcome, i.e. an order of costs was made, which you say you shouldn't have to pay because you were right, is that a sufficient reason for saying it's not academic?
Well, to be honest, I hadn't even looked at that point.
Okay,
because
well,
it
no.
seemed to me our best point was it wasn't academic in
Okay,
terms
no,
of the
well, if you're not taking the point,
decision-making
that's fine.
process.
Okay.
I may have missed something I should have thought about there. Could I reserve my position on that
All right.
just very briefly, and I'll come back and deal with it if I have to.
Thank you. Okay, so that's why not academic.
Yeah. If it is academic, we say the circumstances are exceptional, really for the reasons that we have just given in respect of our first point. It's not simply the case of these two appellants, but as Lady Justice Andrews pointed out, there are other cases in the queue where proceedings have actually been issued. But beyond that, this is plainly a point that is capable of impacting a really substantial number of other applications.
And you would say it's a point of law which will apply to all of those. It's not going to turn on the specific fact.
Yes, it doesn't turn on the
Now,
specific facts.
let's again just see about that. Insofar as the point turns on the biometrics deferral box, that's a historic point. But I suspect, unless you tell me to the contrary, that at least the 9 we know about made an application at an earlier stage while before the box had been amended.
I don't know, but I will take instructions on
Well, I
whether
think we
all
will
of the
assume
9
that
are
unless we're told to the
pre-amendment.
contrary. It was amended quite recently, I think, the
Yes,
box. It took
I think
some
it was
time.
April. So my understanding is that all 9 are pre-April cases, but I wouldn't want to say something that wasn't accurate. So can we
The
No.
say that-
overwhelming likelihood is the number of those must be, or like the overwhelming likelihood is the number of them at least.
Oh yes, definitely.
And the same really apply for the ARAP, if, which is the only point that will formally be decided on this appeal, under the original guidance you could apply under the ARAP form. It's quite clear you can't under the new guidance. But that change was only in March. So at least for those 9, if they made ARAP applications, which at some point they asked to be treated as LOTR applications as well, either from the start or later, it won't be academic for them either.
No.
Or it was that's not your
And
point,
it
but it will have implications for them.
It will bite. Yes, absolutely.
Okay.
And then the wider significance we've referred to in our first argument, I hope you've picked up, is that there are tens of thousands of ARAP applications in the pipeline. These are people who were former British employees, direct employees, locally employed staff, or the additional 4th category of special cases.
But why would this decision affect them if they are within ARAP?
Because people who are not within ARAP will be in...
Oh, holding them up.
Yes, exactly.
Right.
Exactly.
Yeah.
Yeah.
My fault.
And so the MOD will have arriving on its desk potentially thousands of applications for people who, well, weren't locally employed staff, don't fall under the eligibility provisions for a relocation package, but say, well, the courts have said that this is the most straightforward way for us to apply for consideration outside the rules.
That's not going to happen because the new form, the new guidance says you can't use ARAP anyway. So I'm not sure it helps academic.
No. Well, I hope that's right, because Mrs. Justice Laing considered that her reasoning cast grave doubt on the lawfulness of
Well,
the
it
new
did.
guidance.
She did. And I mean, I think, are you going to be asking us to say anything about it? Would, very strictly speaking, be obiter.
Well, it would. And we say we win on the prior step, because even without that additional line in the guidance,
yes, but
applying
suppose you lose on that. It's going to be slightly unsatisfactory to leave Mrs. Justice Lang's hint sitting there. It will be open to us to say something definitive about it, one way or the other, say she was right or she was wrong, but it would mean the argument went quite a lot wider than it may have been intended to, or expected to, or we could give we could either endorse her hint as a hint or give a counter hint.
well,
I think we may just have to see how we go
yes.
on that.
If we said that the version 1 as a matter of construction meant what Ms. Neg says, that doesn't help the problem for the second version. If we said the first version was irrational, then logically the second one may be irrational too. It all depends. Well, no, you might say, no, not irrational.
Yeah. Well, I think this is, anyway, that's in a sense, that is another problem we have, but I don't think it's directly material to the question whether it's academic.
Well, except that when we're looking at the significance and the general public importance, whether there are exceptional reasons, even if it were academic, for the court to proceed, we would say this is quintessentially the sort of case where everybody having prepared, if it has become academic, our primary position it hasn't, it only became academic days before the hearing.
Yes.
And the implications are so significant and important. And it's not simply a matter of administrative convenience for the Home Office or the MOD. It's the people who are in Afghanistan waiting for their applications to be considered.
Very well. That's really what you need to say about that, is it?
Yeah.
Let's hear from Ms. Nike, just obviously on points 1 and 2. Is it academic? And secondly, even if it is, should we proceed? Is it strictly academic?
My Lord, I accept what my learned friend, Ms. Giovanetti, says, which is that the Secretary of State for the Home Department has only made a decision in principle for leave outside the rules. However, that is the primary decision that the claimants seek or sought, and they now have that. And they're now in the process, as my learned friend.
Well, what about her point that it's in principle only?
Well, my Lord, if they succeed in their challenge, which is now not quite afoot, but it's been pre-actioned, then what will happen is that they'll either get a decision from a court saying that decision was unlawful, and then what follows then was how to then progress the application.
No, that one isn't right. If Ms. Giovanetti wins, the decision from the court will be, I don't need to consider this in principle decision because there was never an application that was valid.
Well, my Lord, once the in principle decision has been made, and that was made in another case of which Ms. Giovanetti, I think, was in court, there was another decision. Secretary of State has adopted this position in another case called JZ, which is not before the court. But
Well, that's another annoyance that we see lots of correspondence littered with references to JZ, but we haven't been given anything about it.
Yes,
anyway, stick on to this case.
On this case, the core question in terms of getting a decision which engages with the merits of the application is something that the two claimants have now received. And because it's negative, and it's useful for the court, because it sort of illustrates the problem of not comparing an application outside the rules with ARAP, but on the individual claimants, they've got the decisions that they want.
If Ms. Giovanetti wins, she could withdraw the decision tomorrow and say it was an in-principle decision done on the basis that there was a valid application, and in fact there never was.
Well, if she didn't make the decision, as I understand it, those two decisions were not made on the basis that there was a valid application to be made. She just made a decision to consider it in principle. That's something that.
Well, I'm about to say,
perhaps
we better have a quick look, but
Might be worth just looking at this.
In a sense, even if it wasn't spelled out, it would be implicit in the fact that she was appealing to this court, that she was doing it because the judge told her she must. If the judge was wrong to tell her she must, she can withdraw it.
What she said, well, my lord, if that's a risk, then of course that does change the tenor of the question of academic. But a paragraph, so it's if I take you to S, my lord, to S, click tab 7.
I haven't got any tabs.
I haven't got tabs now. I haven't even got a hard
We've got
copy.
pages though.
Page 46, my lord. My lord. Paragraph 2.
Hold on, I've got to scroll there now because.
Just give us a moment. I think we can just read this for ourselves. Well, unless we've obviously skim read this before, but for the purpose of the point we're on at the moment, really the only relevant things are that she has described it as, quote, an in principle decision in paragraph 2, and at the end has called it a pre-decision. Anyone reading that in context would mean that she is preserving her position that actually no decision yet falls to be made because there hasn't been a valid application, but the judge has found otherwise, and she's got to go ahead and do it.
I mean, my lord, on the basis of what Mrs. Justice Laing found, on the basis of Lady Justice Andrews' order, this isn't compliant with that order, which is in compliance with those orders, she should have made a decision, just a decision on and treated the application.
Well, all right, but I mean, suppose you're right, then you just cross out those words, but you still have the position that it is clear that she did it because the judge told her she must.
But not in the
judge is, but everyone knew there was a pending appeal. It would be absurd if the appeal succeeds and so that there wasn't ever a valid application, that she should be stuck with her decision.
Well, perhaps this is just a victim of timing. The Secretary of State says, well, you know, we've now got this decision, but it was within her. She made it on the 22nd of July. This is we've been seeking a decision on the applications, and she hadn't made those decisions because of her position. She's not It's neither one thing nor another.
Okay, but I think we understand your position on. You say that this is an effective decision. What do you say about whether it would be withdrawn if the appeal succeeded?
Well, there's no need if the appeal succeeds, it doesn't need to be withdrawn because the Secretary of State has said it's an application. It's only an in principle application. Sorry, an in principle decision, and she expressly says that before the forms have been submitted and the biometric data has been submitted. And importantly for the claimant, it now gives them the opportunity to engage, as we see in the pre-action, the court doesn't need to look at that necessarily, but to then engage with the substantive challenge to the reasoning. And if that succeeds, then we'll go on to pressing the question of how to implement that. But
no, okay. Well, that's the. What about the second point? Suppose that we are with you on that, and it is suggested that. Even if it is formally academic, it should be allowed to proceed without an indemnity as to costs because of the implication for other cases.
Well, if it is academic in the individual claimant's case, is what we say, but if it does affect other cases, we say there should be an indemnity. That's
a classic case for an indemnity. Yes, sir.
Because the claimants are two impecunious judges who are in Afghanistan.
Can we just pause there? I didn't pick you up on this, Miss Giovanetti, but isn't Miss Knight right that your second? You may or may not be right on your first point. If you're wrong on your first point, i.e., it is academic in these cases, and you're asking for it to go ahead because exceptionally it affects all these other cases, fine, but then isn't that just a case where you have to give an indemnity as to cost? There isn't a middle position where there's something special why you shouldn't have to, is there?
That might well be the case in AZ's case. feels counterintuitive that S should get indemnified on costs when actually, if we'd been told and the court had been told the true position, there would never have been a pre-decision in S's case.
Okay, well, hang on, that's a separate point. That emerges from the fact that she's in
Pakistan, and has been
but
since
conceptually,
judgment.
if we're just talking about the pre-decisions, isn't Ms. Knight right that there shouldn't be if it is not, so if it is academic in their cases, but you wanted to go ahead for the greater good, you ought to give an indemnity, shouldn't you?
It's not just for the greater good. I suppose that's why I say it's very linked to the first point. It's because we're only in this position because we've tried to assist them in advancing their own cases by giving substantive reasoning.
Yeah, but if it is academic and it's not going to affect their cases, then the only reason you want to be here is because it's affecting other cases.
Well, I think
so why should they have to pay the costs to help you out?
No.
They're doing a very big service by making sure the point is argued, and you're asking them to pay for the pleasure.
No. Yeah. I think that's a fair point. But what I'd say, I suppose, against that is that in S's case, we're in a very different situation because there would not have been a pre-decision in those terms if we'd known about the true state of affairs.
Well, I'm anxious to get onto substance if we're going to. Ms. Knight, I think you will appreciate from that intervention that we got your second point. And we heard what Ms. Giovanetti has to say about it. I think we'll rise and see where we are. Nothing you're bursting to say.
The only thing I'm bursting to say is that the reason S was under pressure to leave was because her son was abducted and she had to leave to go to Pakistan.
Well, there may be all sorts of personal reasons, but and I'm certainly not going to give you a hard time about it, but it was clearly wrong that people weren't put in the position as soon as you knew. Home Office had been told, and I hope lessons have been learnt about that. But we do appreciate mistakes happen. Right.
Yes, this is the point.
We need to correct that.
One of the witnesses.
Yeah.
We know that now because they're given a secure link. That's process you in they send them a secure link and then they can access.
That was just my sort of paraphrasing. Yeah, sorry.
Yes, okay.
Yeah.
Related.
Very well, we have decided that the hearing should proceed. Happy to tell you, as it were provisionally, that it's provisionally our view that it is not academic for the reasons advanced by Ms. Giovanetti, but because these are not entirely straightforward questions, we will not definitively decide that. we will decide that at the time of when we hand down our judgment and give our reasons. And if we, on further reflection, think that it is academic, then the undertaking will be, as it were, activated, so you're protected.
Thank you very much, my lord, my lady.
Just give me one moment to write that down. Yes, substance.
Substance. So I've outlined very briefly the sort of scheme of my submissions. I'm going to address first the scheme for applying for leave to enter the UK from abroad, both under the immigration rules and outside the immigration rules. I can do that very briefly because I know this is an area with which all members of the court will be very familiar. So I won't take you to the authorities, but as the court will know from ALVI, which is at page 122 of the authorities bundle, the criteria to be met by a person seeking leave to enter must now be set out in the immigration rules. So post-ALVI, the immigration rules contain extremely detailed provisions governing the grant of leave to enter on various bases, including the points-based system, visits. I found that the particularity when I was looking at these yesterday included a specific scheme to apply for leave to enter as the partner of a retired person of independent means who's residing in the UK. So there are so many different categories, all set out in the immigration rules. And I have a feeling that it's my Lord Justice Underhill who has previously referred to the scheme as being either Byzantine or Byzantine. I never know quite how to pronounce it. But you're not alone in having said
Well,
that.
no, I'm afraid it's not me. That was Lord Justice Jackson.
Oh, right.
I was always thought that was slightly unfair to the Byzantines, but anyway, plenty of people have said that.
Yes. And for visa nationals seeking to enter the UK, the person must have prior entry clearance in the form of a visa. And you have that in the immigration rules, which are in the authorities bundle. We don't need to turn it up, but it's paragraphs 24 and 25, pages 13 and 14 of the authorities bundle. As we know, from paragraph 44 of Munir, which is also in the authorities bundle, the decision starts at page 169, and at paragraph 44, page 183, we have clear confirmation that the 1971 Act also confers a very wide power to grant leave in the exercise of discretion outside the rules.
So Alvi and Munir must be consistent.
Yes.
So
Yeah. Same
when
for
Alvi says the criteria must be set out in the rules, that is for all the typical cases,
yes,
but without prejudice to the right asserted in Munir to cater for non-typical cases.
yes. And Munir, which
Outside the
is,
rules.
as my Lord may recall, a much shorter decision, sort of explains that the more prescriptive criteria you apply in particular contexts, the more likely it is that what you've actually got is a rule, which would need to be in the immigration rules. But where you have guidance about the sorts of circumstances where leave may or may not be granted, that's more appropriately dealt with in guidance and by way of leave outside the rules.
Yes, thank you.
And so indeed the process as well as the approach for seeking leave outside the rules is set out in guidance, and it's long-standing guidance. Version 1 was issued more than 5 years ago, in February 2018, And you have that in the supplementary bundle at page 196. This is the version of the Leave Outside the Immigration Rules guidance that was published in February 2018. You've also got in the bundle the updated guidance, the only update being
So sorry,
changed.
just give me the page reference for
Sorry,
version 1.
Page 196
Yeah. Thank you, yes.
is version 1,
Yeah.
which is in force from February 2018 to March 2022. And then sequentially following that, starting at page 208, you have the updated guidance dated 9th of March 2022. And if you look at page 210, the very bottom paragraph changes from last version of this guidance. You'll see the only change was the update to clarify that an application for leave outside the rules cannot be made.
When you
On
say
an
clarify, the other alternative is that it amended. That's the whole
Quite
question.
right.
So
No,
by saying
but-
clarify, you're already
Yes.
presupposing the answer to the question we're here to decide. You
Yes.
don't fall into a trap.
No, my lord's absolutely right. I was sort of summarising what it says. Obviously, it's setting out the Secretary of State's position, which is that it was clarification. But on the judge's analysis, it was
It changed.
a change. Yes.
Yes. Now, are you going to pause and look at what it says about applying, or are you coming back to that later?
I was going to take you to the original guidance because what I
Yes,
was really
well-
trying to highlight was that that was the only.
No, that's fine. Well, I'm ready when you are.
So if we start at page 200, under the heading background, see the guidance records that the immigration rules are designed to provide for the vast majority of those wishing to enter or remain in the UK. The Secretary of State has power to grant leave on a discretionary basis outside the immigration rules from the residual discretion under the 1971 Act.
Yeah.
Picking it up, the last complete paragraph on the page, beginning LOTR on compelling compassionate grounds, you will see the guidance sets out the general substantive approach to leave outside the rules. LOTR on compelling compassionate grounds may be granted where the decision maker decides that the specific circumstances of the case include exceptional circumstances. These circumstances will mean the refusal will result in unjustifiably harsh consequences for the applicant or their family, but which don't render refusal a breach of Article 8, Article 3 of the Convention on Human Rights, Refugee Convention, or other obligations. Not all lottery is granted for the same reason, and discretion is applied in different ways depending on the circumstances of the claim and the applicant's circumstances. The next heading, important principles. A grant of leave outside the rules should be rare. And the starting point is that as a matter of immigration policy, the routes for coming to the UK have been identified and provision has been made for them in the immigration rules. And importantly, in the second paragraph there, the immigration rules have been written with clear objectives, and applicants are expected to make an application for leave to enter or remain in the UK on an appropriate route under the relevant immigration rules and meet the requirements of the category under which they're applying, including paying any fees due. Considerations of whether to grant leave outside the rules shouldn't undermine the objectives of the rules or create a parallel regime for those who do not meet them. You then have guidance about the period of leave outside the rules to be granted in the final paragraph under that heading, important principles. Then under the following heading, reasons to grant leave outside the rules, there is further guidance about that, and you'll see it set out by reference to sort of examples. Again, within Munir, rather than identifying criteria, the guidance gives examples of the sorts of situations where leave outside the rules may be appropriate. I don't think we need to look for our purposes at the documentary evidence section or in respect of those with children, but if you turn over to page 204, you will see that the guidance then goes on to deal with the process, and of course that is important now. You can apply for leave outside the rules overseas or from within the UK, because it may be leave outside the rules, leave to remain, for example. We're concerned with the first paragraph applying overseas for leave outside the rules. Applicants overseas must apply on the application form for the route which most closely matches their circumstances and pay the relevant fees and charges.
Do those underlinings indicate hyperlinks?
I'm not sure they do. We'll check. Any compelling, compassionate factors they wish to be considered, including any documentary evidence, must be raised within the application for entry clearance on their chosen route. So it's plain that the application form they're talking about there is an application for entry clearance. That'll be important when we come to look at the ARAP scheme and
it's
how
clear
that
that it
works.
may well be the sort of thing they're talking about, but it's very general. It's really talking about the route by which you get into the United Kingdom. And in most instances, we know the route by which you get into the United Kingdom is by something under the rules.
Yes. I'm not sure I'd necessarily accept that, my lord.
Okay.
Yeah, I mean, the starting point is that applicants overseas have got to apply on the application form.
Mm-hmm.
And the application form from line 4 we see is the application for entry clearance on their chosen
So it's
route.
got to be an application form which leads to a route under the rules. It's got to be an application form which leads to the grant under the rules of leave, and you pick the application form that will most closely match
Yeah,
the set of rules in the rules that you say you are likely to meet.
yes.
I've seen plenty of these both online and not. I don't know whether you've yet had someone tug your gown from behind, but normally these underlinings are hyperlinks. There can't be any reason why they wouldn't be underlined otherwise.
Yes, they are hyperlinked.
Where does it link to? Where does the application form link to?
It links to the page that says applying for a visa to come to the UK.
Do we have that in the bundle?
No, we could
Can
send
someone
it.
get it?
Yeah.
Hang on. So it's a page of what?
It's a gov.uk website.
But it's not part of this guidance. So sometimes you have hyperlinks which are internal to the
No,
guidance.
it's not. It's a different page, and it's the page that gives you the guidance. on
Okay, but I
applying
think
for
I would like to see what it's a
visa.
page of, because you don't just have, or maybe you do, but on the website you don't just have pages; they're grouped together as
Yes.
parts of documents, or at any rate, subject matters. So can someone do that research?
Yes, we'll do that, and we'll provide that to the court as soon as we can.
So sorry to interrupt, but at page 149 of the supplementary bundle, exhibited to Mr. Golding's witness statement, that's where those have been briefed.
Well, are we sure that I've seen that page? And I think, but are we sure that that is what is being referred to?
That,
It may be. I'm
yes,
just.
we hope
I
this
think,
is correct,
well,
but I will
Miss
let-
Masood has just obviously been doing it. Miss Masood, can you check
Okay.
that
It's the same page.
that is the one? Thank you, Miss Knight. That's very helpful.
Thank you very much.
Okay.
If
We'll
hang on a
check
somebody-
to make sure, but
like me had a computer but wasn't awfully keen on them, what would happen? I'd click the application form box, I'll empty into 149, and there are other boxes that says choose a visa and so on. Is there a computer will only direct you to certain boxes route, or is this general giving you an indication, because it doesn't really cater to the situation where you've had an invasion of another country and the question is whether or not you ought to extend a degree of protection. It wouldn't cover ARAP, it wouldn't cover those we are actually employing. So what's the relevance of getting to page 149 then?
Well, somebody who was applying ARAP who fell within the locally employed staff wouldn't be starting off with a lot of guidance anyway. So we're...
No, but all right. But well, perhaps my Lord will say if I'm asking a different question, but I think it's the same question. The phrase hyperlinked is application form. You tell them, so I'm sure rightly, it takes us to what we've got at 149. That doesn't immediately have any forms. It's full of generalities.
Well, are there, I think there are links, aren't there?
Are there?
Different visas. Yeah, for example, if you look at page 150, you want to visit the UK, apply for a standard visit visa, and then there's a...
Well, there isn't a link there to a form. Perhaps has anyone got that page open on the computer?
Yes.
Take my lady's example. If you want to study in the UK, a standard visitor visa, it then gives a web address. Is that hyperlinked? It doesn't look as if it is.
Standard visitor visa lets you do a short course of
No,
study.
yes, exactly. But sorry, a standard visitor visa. Then there's a bracket: https// standard.
And that links hyperlink.
Well, is that is a hyperlink? Is
yes,
it? It's in blue, is it?
If you standard visitor.
So
Okay.
it links to what?
Where it says a standard visitor visa and it's underlined, that's hyperlinked.
Well, it isn't underlined in our version.
It is underlined in this version.
Okay, but it's in blue, is it?
Sorry?
Oh, I see. Well, it doesn't. Okay, that is a hyperlink.
It's a hyperlink and it hyperlinks to the page that says visit the UK as a standard visitor.
Okay, does that have a form on it? Somewhere you've got to get to a form.
Yes, it's a series of guidance.
Yes.
And then apply for a standard visitor visa. Apply now. Yes, that then takes you to a page where you click on a box.
And a form comes up.
I'm hoping so.
Is that right?
Yes.
Well, that's what I was expecting. I just wanted to see how it worked.
Yes.
So going right back to where we started, 204, let's apply on the application form. If you click that and keep on clicking, you will eventually get to the form for whichever route you choose.
A series of visa application forms.
Okay.
And what if you click all of those and you think, well, none of those fit me?
Well, that's... Yes. Perhaps I think you're going to come back to that.
I think that's why it doesn't say apply on the application form for the route which matches their circumstances, because the premise of having to apply outside the rules is that none of the routes will precisely
Yes, well,
match.
I see all that, and that's the point you've made. Again, sorry, I'm rudely taking over from my lord, but I think it comes to the same point. As by definition, none of them do match your circumstances completely, and it may well be, as the judge found, and frankly, unless you try and persuade me otherwise, rightly found, none of them comes close to matching the circumstances. Certainly, there's nothing in your skeleton argument to say this is what the closest one is. You just say well, they can choose. So we'll come in a minute to all the points that are made about how awkward it is to have to fill in an inappropriate form, which may make you say things that aren't true and so on. But at the moment, why can't you have a form for LOTR? You say, well, because it's outside the rules, but that's a non sequitur. You can have an application under LOTR. As soon as you can do that, why can't it be a form?
Yes.
A form is just a bit of paper which is easy for the Home Office to handle.
Yes. Well,
And there's nothing in the evidence that addresses that.
No. And I anticipated you were going to ask that. It's a question I have been asking, and the the answer I have been given is always precisely as my Lord anticipated, which is this is not a single, clear, defined route. This is supposed to be a residual category for truly exceptional cases where we can't define in advance the sort of questions that would be relevant.
Well,
There-
sorry. Forgive me, it's a dialectical process. I know what you've made the essential point, but the answer surely is the form would look like this. It would have all the basic admin stuff that you need to know: name, date of birth, who you're applying for, dependents, quite a lot of stuff. Where are you? All this biometrics. And then it would say, why do you say you're entitled to leave outside the rules?
Yes.
You don't have to guess what questions to ask. That's their problem.
Yeah.
You could also say, and why do you say it doesn't fall within any of the rules? Why do you say you've got to apply by this route rather than by one of the established routes? You could ask that if you like, in case that wasn't apparent from the reason they've given. But the idea you can't do that seems to me, at the moment, isn't very convincing.
I don't think it's part of my answer that you can't do that. It's that the Home Secretary has decided, and successive Home Secretaries have decided, that it's not desirable as a matter of policy and administration.
Hang on one
to do
second.
that.
Hang on one second. Now, I don't think there's any evidence about this, but we'll hear it from you without evidence at the moment. Not desirable or good administration, is that the phrase you used?
Not desirable, I think I said, for reasons of policy and good administration.
Thank you. I want to get this down right. Clear for reasons of policy and good administration. Why not? I don't see why. If the alternative is to have to fill in a form which is, by definition, not appropriate, it seems to me illogical not to have a general form that is appropriate.
No.
I haven't seen what the policy problem is.
I mean, there is intelligence before you. I think the best I can say is that it's to make it, well, part of the rationale is this is not a route. You have application forms, and these are application forms for recognised established routes for coming to the United Kingdom. It would be suggesting that as well as all the specific routes like partner of a retired person of independent means, there is another route that's available generally if you don't fit any of those, but you'd still like to come to
But that is the
United
case, isn't it? I know route has a rather technical meaning.
Yes.
In one sense, you're obviously right. It isn't a route because route has a technical meaning. But in a more common sense, it is a route. It's a route outside the rules. And you're not saying there isn't such a thing as leave outside the rules.
No,
And so
no.
it's a route with a small r. And then it's just a question of why don't you make it... people are going to apply anyway. Not very often.
No.
Perhaps not very, even less often justifiably. But as soon as you say they can apply and will sometimes have a good case, why can't you have a form that allows them to advance that case?
I can see that there may be some powerful arguments for having a form, but there isn't a form. And obviously, we would say that the test is a rationality one, and a particularly high sort of Johnson rationality one.
Yeah.
Because it's really not for the courts to say, well, we think it would work very much better if you had a specific form. Maybe it would.
Well, the problem is,
Oh, I'm sorry.
it's not just we're saying we could devise a better system for you, we know better than you. We might even be right, but as you say, it's not our job. But if the alternative is that someone with X hypothesized potentially a good case is put in a position where they are hindered in making, maybe even on an extreme view, prevented from making a valid application, then it comes out of the route, out of the realm of things that the Secretary of State can do, even though they don't do them as well as we would like, to things they simply shouldn't do at all because of the effect it has on an applicant.
I hear what my Lord says, but this is a system that has been, I think that's why I started off by saying this guidance has been in place since 2018, and it works generally across a wide variety of contexts. So, for example, Ms. Masood and I have recently been doing a case which is still pending before the Administrative Court about parents who want to come to the United Kingdom to join children who've got refugee status. There is not a route under the immigration rules for that. There isn't a specific form for that. What's generally done, and what was done in our case, is that the parents apply using the form for joining a partner in the UK. Well, obviously they're not joining a partner. Nobody's ever suggested that this is deception or misleading, that they can be refused on that basis, because
But
their
it is
form says...
misleading and it is deceptive, because they are not joining a partner. You have an elderly parent who wants to write in and say, I'm dying, I've got 12 months to live, my son is in the United Kingdom, please let me join him. And in the middle of all her grief, she has to write a form saying, I'm joining my partner. She's not joining her partner.
Well, the form's entitled joining a partner, but the answer that's given in the Secretary of State's evidence you'll have seen is you simply put not applicable in the boxes that say who is your
You
partner.
don't use the form most closely relevant, use a form that's not relevant at all and say it's not applicable.
Yeah.
Can I ask you a different question?
Yeah.
This is only guidance. It's a statutory power to grant or refuse leave. You can have guidance, but you must be willing to depart from it.
Yes.
If somebody writes in and says, all of these forms are equally inapplicable to me, please consider this letter and my attached statement, please. You'd have to consider that, wouldn't you?
Can I think about that? I mean, because we'd say that the answer is that it's not unlawful or irrational of the Secretary of State to respond saying, of course I will consider your application, but you should make it using this form.
No, she's written in and said, I'm asking you to depart from the guidance. That's the whole point.
Yeah.
And you can't write back and say you must follow the guidance. That's not an answer to whether or not you should depart from the guidance.
Yeah, no, I hear the way my Lord puts it. The Secretary of State's position is that she will not depart from the guidance that you have to use a form unless there are compelling reasons to do so, which is why, I mean, that's been her consistent position in these cases, that she has been writing to people saying, please make your application using a visa application form.
If she's doing that all the time, then she's acting unlawfully because she has vetted it.
No, I mean, it's not that she does that all the time, because as you've heard in JZ's case, for example, the Secretary of State was willing to accept a screenshot of a visa application form, which included the box that he couldn't tick, which was confirmation that he could attend a visa application centre. So I'm not saying it's a immovable position. I'm just saying it's the general position. My Lord's, of course, absolutely right, that if it was I will never move from that, whatever the circumstances, it would self-evidently be unlawful purely on that basis.
Is there evidence that she considered the solicitor's letters that said we'd like you to consider this application, even though by definition there's no form?
Yeah, you've got the responses, I think, in the clip.
In the clip.
I'm going rather ahead of myself.
Okay, sorry.
No. So if probably and there's a lot of correspondence, probably the key one in S is the letter of 11th of April, which is at page 73 of the clip from Wilson's. You may have read this. This is the one which explains...
Yeah, I haven't got page numbers, I haven't got tabs, I haven't got a hard bundle.
Sorry.
Have you not got page numbers at the bottom?
I have got page numbers, not at the side, so I can't work out.
But you can
Well, if I was given the page number, I could at least... But I can't see this letter. Oh, no, hang on, I've got the... I've identified the
hard
letter.
copy's coming up.
No, don't worry, I've got the letter now, the 11th of April, yeah. I've got page numbers in the bottom, but I've got to know which one it is. But I have got a letter dated the 11th of April 2022.
Could I hand this up?
What?
An
Usher.
unmarked hard
Usher.
copy. Sorry.
What page was it for the...
73, my Lord.
73.
Yes, I've got that on the screen now. It's just a process of elimination to get to it.
For future reference, then why don't we?
Thanks.
I don't know if you...
So which passage exactly are you taking us to, Ms. Giovanetti?
So probably paragraphs 3, 4 and 5.
Why not 1?
Oh, 1. All of
The
them.
purpose of this letter is to request that you treat our client's application under ARAP as a valid application for leave outside the rules.
Yes. Well, yes, absolutely. Well, I've taken you to this letter, but it's just that this is the letter which raises the argument that there's no alternative visa route or form that matches her circumstances. That's why I thought you'd be particularly interested in paragraphs 3, 4, etc.
Yes, we got. So that my Lord's question was: did you consider such an application, i.e., to depart from the guidance? Pretty explicitly saying, depart from the guidance, and giving reasons why it couldn't be. The guidance didn't work in that case. And what was your response?
The response is on pages 75 and signatures on 76.
So ignore A for the moment. Yes, I think my Lord's point was a slightly different one, which was not about use of the ARAP form, and that maybe the thing has been made more complicated by that. But suppose that Wilson's letter had been very slightly different and had said, okay, don't use the ARAP form, but use the representations in this letter or referring to some previous letter where their substantive points have been made. Because your general policy of saying choose the most appropriate form doesn't work here because there isn't one that's even at all appropriate. I think the question was, is there any evidence that you gave reasons for not doing that? The answer from this exchange is, in a sense, you were focusing, perhaps fair enough, on the actual point made, which was why not treat the ARAP form?
Yeah.
Which is a complicating factor.
And I think probably it's complicated further by the fact that the Secretary of State's reasons for considering forms are important were being set out in the evidence and submissions and detailed grounds.
Well, so this certainly cross-refers to the amended grounds of resistance, which I have looked at separately, but I haven't followed up in this context.
Because you could read it. I mean, these are just shorthand descriptions of things. You could read paragraph 1 and say, could you please treat the pieces of paper that have on the top the words application under ARAP as the piece of paper by which we are asking you to consider exercising your statutory discretion under section 3. And that's what it's really saying. It's saying, look at the information we've given you under that form and please decide whether to give us leave outside the rules. And you'd have to do that, wouldn't you? As a matter of law, and you'd seem not to have done that.
Well, I wouldn't expect necessarily the Secretary of State does have to.
She has to consider whether or not to
consider whether or not to do it.
Yes.
Whether or not to do it, yeah. And you've seen her position is she wants a form filled in, and the explanation is in the evidence, which is that the form generates a process which allocates a reference number, which sets off the process for biometrics to be obtained. And that is just
we're going in circles. If somebody writes in and we said, oh, the ARAP form is a complication, and I'm saying, forget the words ARAP, use that as the heading on the title. You're not saying at the moment that you've considered but decided against, or perhaps you are saying, departing from your guidance. You're insisting always that you must do that thing which the guidance says you should do.
I think I'm saying that Secretary of State's general position is that in the absence of some pretty compelling reason why the guidance can't be followed, the guidance ought to be the starting point, that you apply on the form that most closely approximates your reasons for seeking.
Well, perhaps we can ask you another question I suspect you will have anticipated. So far, the Secretary of State has taken the clear position, not for us to say what's most appropriate, because you know what your circumstances are and we don't. You do now know what their circumstances are sufficiently. are you prepared to say what you would expect to be the most appropriate form, if not ARAP?
No. And the reason I'm not is because there is no necessarily a single most appropriate form. My instructions are that it's extremely rare for the Secretary of State ever to say to somebody, you have used the wrong visa application form to apply for LOTR. You've applied on a visit visa where you should have applied on a family visa. In JZ's case, for example, which is the one that's referred to in that letter, JZ did have family in the UK. He's got a brother here. What he'd decided to do was fill in a visitor visa application form. Nobody took any issue with that. They just wanted a visa application form to set off the administrative processes of generating a number, generating the biometrics process.
Why didn't they have one called LOTR then?
Beg your pardon?
Why didn't they have a form called LOTR? And if they don't want that...
We've got two answers to that, but...
My answer won't improve by my repeating it.
Yes, I mean, at some point... Well, it sounds like an exercise we can't do because we haven't got the material. I would like at least to skim read all these forms and get a feel about what the problems are. I mean, Ms. Terenius, in her witness statement, refers to a couple, but they were, in a sense, the forensic points. They're ones that obviously were inappropriate, but maybe there are more appropriate forms. That's why I wanted to give you the opportunity to suggest one. If I see, for principled reasons, you don't want to do so, fine. We'll have to do the best we can.
Yes.
Anyway, as inevitably happens, we're being bombarded with questions while you're still giving us the introductory materials. We'll let you get back on course and see what's left you haven't yet had a chance to say.
Okay, I will come back to how you can complete a form, if I may.
Yes. So we all jumped off from page 204 about 20 minutes ago.
Yes.
And we got there by looking through the hyperlinks you got from application form. I won't. There'll similarly be one for relevant fees and charges.
Yes.
If you follow that through, how will you discover what the relevant fees and charges are for an LOTR application? You
pay the relevant fees and charges for whichever visa application route you fill in.
Oh, I see. Do they all cost the same?
No, they don't.
So if you were really well advised and weren't troubled by the things that troubled the claimants here, you'd search around for the cheapest.
Yes. Yeah. Yes, it is. Yes. And that's
you
very
write it
often
not
what
applicable
happens.
for all the boxes, save for the one that says cheapest one going, and then you tick that box. Gosh.
I suspect there is a degree of pragmatism about which forms are selected for very much that reason. And again, I probably should emphasise the Secretary of State is not complaining about any of that. The real issue is about using the ARAP form, which is what I'd like to turn to next, if I may.
Yes. Thank you.
So, there is no dispute but that an ARAP application may, further down the line, lead to the grant of leave to enter or a visa. But an application for ARAP, you can call it an ARAP application, is not of itself an application for leave to enter or for a visa. And rather than looking at labels, it's probably most helpful to look at the guidance which explains how the ARAP scheme operates, and I don't know if you've had a chance to
Could you just talk us through the form? We raised it at the beginning. I'm looking at page 5, and tell us what happens. Does the individual ever do anything more than fill out this form? And at what stage does something else get created, which is an application for a visa, as opposed to the application on page 5?
That is precisely what I'm trying to address, and I wonder if I
Well,
can
but
do
you really want to go to the guidance first to get to my lord's point. I wouldn't
Yes,
stop
I
there.
do, exactly that.
Okay.
Because the guidance explains how the ARAP process works.
And it is to be assumed, is it? I mean, that anyone filling in an ARAP form has the ARAP guidance available to them.
It would be, yeah, I mean, that's what you'd expect them to do.
Yeah.
There's a central ARAP guidance, and I suspect because it's for locally employed staff, they will all be very
Yes, but what I want to be clear about is that it's available to the guidance is available to the same extent as the form itself is available.
Yes, it's all available online. I'm sure I'll be told if that's wrong, but yeah, it always has been.
Okay, where is it in our papers?
I've just got to find my bundle. It's in the second supplementary bundle, and you'll see if you open that and look at the index that there are
Yes,
a
I see.
number of documents headed or labelled as ARAP policy guidance.
Yes.
In fact, the key one is the one at number 11, pages 41 to 62, which is the main guidance, and that explains the ARAP scheme. So it starts at page 41, Afghan locally employed staff relocation schemes, and you'll see this is version 3 and is the version that was published on the 1st of September 2021.
Yes, now just so that we don't confuse ourselves later, why are we, if we just looked at the index, you might have thought that the previous documents, which are all headed ARAP policy guidance, would be more relevant, but they're not.
No,
What are they?
Isn't very helpful because this is the central guidance, and then if you look at them, for example, if you turn to page 13,
Yes.
which is the September document, you'll see it says Afghan relocations and assistance policy, further information on eligibility criteria, offer details and how to apply. So all of these, the first 10, are the further information pages at different times.
Yes, I see. Okay. I mean, I just, as long as we understand why they're not relevant, I don't need the details.
I am going to take you to precisely this document.
Right, but the starting point is the ARAP guidance at page 41,
absolutely.
right?
I do just pure chance, because I looked at page 15, just because it's hinted that it will tell you how to apply under ARAP, and you'll say yes, but not applying for a visa. But just so it says if any current or former staff believe they now qualify or receive risk, they should use the online application form, and there are lots of hyperlinks there. I just wondered whether that is the form at page 5 or whether it's something else that they've been told.
I think that is the form at page 5. But if you turn over to page 16, I'm taking this slightly out of order. The point about the guidance I was trying to take you to is that it shows you the range of support and assistance that's available. If you look at page 16, do you see the heading, the relocation offer under the ARAP scheme?
Yeah.
The relocation offer creates the possibility for current and former LES, which is locally employed staff, to have the default option to relocate to the UK if they meet the eligibility criteria above. It's offered to locally employed staff whom the UK government considers to have put themselves in the most danger and contributed the most to the UK mission in Afghanistan. The relocation offer is based on recognition of service and an assessment of the likely current and future risk to LES due to the nature of their work for the UK government in the evolving situation in Afghanistan. LES who meet the eligibility criteria for relocation under the ARAP scheme will have the opportunity to apply for limited leave to enter the UK. So what happens, in short, is that you apply on the ARAP form, the short ARAP form, which you've got at the beginning of the bundle, to say, I am a member of locally employed staff or former member of locally employed staff or somebody in the special cases category.
Yeah.
And you've seen the form.
I think we'd understood that. Sorry, but we allowed you to be diverted. But did you not want to show us first the guidance at 41?
I did, but I'm just jumping around so much that having looked at this now, I think probably it's more helpful
enough.
just to carry on with this and then go back to the guidance,
Okay, whichever you'd rather.
if I may.
Yeah.
So the reference at page 16 is to the eligibility criteria for relocation. What's completed is the form that you've got in the additional clip at pages 5
Yep.
and onwards to 9.
Yes. Well, my lord had some questions about this, which we suggested be taken later. But I think at some point we ought to. Is now the time, because
If I just take you to this form and the next form, and then I think against that background, I'll try and address the questions as best I can. So starting at page 5, you'll see that this form is really all about identification and establishing that somebody is eligible under ARAP for assistance as a member of locally employed staff or one of the special categories.
Yeah.
It's a very short form.
Yeah.
And it asks, as well as for identification details, what was your job title? Were you directly employed? What was your employing department? When were you employed from? Are you still employed? When were you employed until? What was your reason for leaving? What location bases did you work at?
And that's it.
And that's pretty much it.
Well, it is it, isn't it?
Is it? Yes.
And that there isn't anything saying I'm particularly at risk or I offered my contribution was specific at all.
Well, there's the...
It isn't on this form.
Not on this form.
So who do you send this form to? If you're the applicant, you type it online, it goes into the ether.
Yeah.
On whose computer, no, it'll never hit your desk. On whose computer will it pop up? Somebody in the Home Office or somebody somewhere else?
Somebody somewhere else. And that's when we go to the main guidance, which explains the process and how that operates.
So on page 5, before we leave page 5, we will contact you if we require any further information surrounding your application. We will contact you informing you of the outcome of your application. The we there is someone else. It's not the Home Office.
It's not the Home Office.
Person we haven't yet met with a laptop somewhere.
Yeah.
Right.
Which person we are now going to
Okay,
meet by
yeah.
reference to the main guidance, which starts at page 41. Should we pick it up at 44?
The two people that you see, the two government departments that we see mentioned on that first page are the FCDO, as we must learn to call it, in the third box, which is actually saying what will happen if you're not eligible with ARAP, so perhaps that isn't very helpful. But the very bottom one saying MOD, is all governed by the MOD privacy policy.
I'm sorry, my lord, I might not be on the same page as you.
Page 5
Oh, you're
of the
back.
clip.
Yep, sorry.
Because this is all about who would be understood by we, and you say we is not the Home Office. And I'm just trying to see what hints there are as to who we is on the form itself.
Yes.
And the two departments mentioned are not the Home Office, but are the Foreign Office and the Ministry of Defence.
That's absolutely right, and those are the relevant departments, and that's why...
Okay, now you're going to take us to the guidance.
Yes.
Back to the guidance. So that's page 41.
The guidance starts at page 41.
Which particular page are you taking us to?
Can we start at 44 about this guidance?
Yeah.
Guidance explains the two schemes designed to help current and former locally employed staff in Afghanistan, the ex gratia scheme and the ARAP, and the process for locally employed staff who qualify to relocate to the UK under those schemes. Eligibility for the schemes is assessed by the employing government department and not the Home Office. Then the
Can I be clear about this? Typically, people who are eligible under ARAP will be employed by the Ministry of Defence. They will be employed the most locally employed Afghan, but presumably the Foreign Office may have, maybe at that point also, the international Development Department was a different department. Doesn't matter anyway.
No.
Foreign Office, possibly one of the other odds and ends, British Council or something.
My understanding is that the vast majority, it's the MOD,
Yeah.
and then there's a small category that may be FCDO.
Okay, thank you.
Could I move on from that? That's sort of key for my purposes, that eligibility for the schemes is assessed by the Employing Government Department.
That just is really whether or not they've been in a department and they've made a contribution. It's all those, it's the criteria. It's not that they will be granted leave.
No.
It's that they are actually somebody who's doing the work for the British government rather than the American government or the Afghani government.
Precisely, yes. Absolutely. If you turn to page 46.
Well, I think we also just need to see, it may not be your key point, but the next paragraph, the guidance also explains to UK VI staff how to consider applications for entry clearance.
Yes. Yes.
I think we can ignore the bit about settlement. And that must mean entry clearance from people who are eligible under ARAP.
Yes. Or the ex gratia scheme, but yes. Because they're the two schemes that fall within the guidance. I'm so sorry, I'd started reading that and then I went back to page 5 and then I didn't go back to that, but yes.
Yeah, don't worry.
So the guidance explains the two schemes for applicants. It's published guidance, but it also provides the guidance to UKVI staff when they come to consider applications.
But what do they consider? I still don't know what they consider. I want to know if there's a different piece of paper from page 5 which from that, and you're telling me there is.
There is, and I'm about to hand it round.
Oh, right.
I wanted to wait
So
till you got to that bit.
Then,
You haven't missed it. I'm so
Right.
sorry, you absolutely haven't missed it.
Right.
I was going to wait till we got to the bit in the guidance that refers to it, and then
Okay, which bit of the guidance
but
is
I'll
that?
Produce it now.
Which page of the guidance are we jumping off from to this form?
I'm so sorry, Miss Wilson spoke to me. Could I?
Which page of the guidance are we jumping off from to what you're handing up?
46.
46, thank you. Okay.
Sorry, Nick. Thank you very much.
And this is what came through this morning, isn't it?
I think it's just come through. It may have come to you electronically as well, but it was provided
Oh, right, okay.
after we arrived here.
Okay, well then maybe it isn't what came through this morning. Right, so what do I write on the top of this? Just so we can refer to it later.
Visa application form.
VAF,
Yeah.
VAF under ARAP.
Under the relocation schemes, yes, this is
Under
actually an
ARAP
integration
relocation.
scheme, but it's the same programme as we've seen the. So yes, ARAP application form. I'm told the ARAP one is identical.
Well, it's been hole punched, so shall we shove it in at the back of the? I'm going to put it at the back of S2. That makes sense.
But shouldn't it come after 5? Because you're leading me to believe that page 5 is when you make an application for a determination of eligibility, and then you're telling me there's a new stage and you complete it, or I'm guessing you're going to say there's a new stage, and the same person completes a second form, which is this form.
I don't. I'm not sure that is what.
Right.
Didn't say. Well, let's not worry about it. Let's just put it somewhere. I'm going to put it as 135 and 136. Well, actually, as it's double-sided, 135, 1 through to 138. Okay. Yep.
So at 46, under background, you've got a brief explanation of the various schemes, including the ex gratia scheme. People who've worked for more than 12 months and then were made redundant or resigned. The intimidation policy was the precursor to ARAP. And then the last paragraph on page 46 moves on to ARAP. ARAP reflects the changing situation in Afghanistan. There are 3 channels for relocation to the UK under the ARAP. First, offers urgent relocation by priority to those assessed to be at risk of serious threat to life due to their work with HMG. Channel open to all current or former staff employed directly by HMG in Afghanistan since 2001, regardless of their role, job, length of service or reason for leaving. The assessment process is informed by regular strategic and operational intelligence reporting. Second channel, relocation by default to a select group of directly employed staff.
But channel is here used in a slightly odd sense, or at any rate a potentially misleading sense. That might suggest, as it were, procedural route, but I think it means theoretical concept.
It does.
Yes, yes.
Then overleaf at the top of page 47, you see the reference to the small group of special cases. For our purposes, precisely who is and isn't eligible is probably not the key thing. We're really interested in how the process works.
Quite.
But the next sub-paragraph is important because it makes plain the fact that ARAP is not just a route to relocation.
No.
So there's a range of support and assistance.
No, we'd understood that, yeah.
You have the policy intention at the middle of that page. Again, refers to the range of support packages, including an option to relocate to the UK.
Yep.
I think we can flick on to page 50, which has an overview of the ex gratia scheme. And then what's key for us...
I mean, a lot of the points is ARAP predated the Taliban takeover.
Yes.
Yeah.
At page 52, you have a reiteration in the first paragraph that eligibility under the policy is assessed by the government department responsible for employing the member of staff and not the Home Office. Then, how to make a claim under ARAP. Could I draw your attention to the third paragraph under that heading? The relocations and assistance policy is administered by a specialist team based in Kabul. The Afghan Threat and Risk Evaluation Unit, ATRIU, which was set up to assist and support local staff who are threatened as a result of their work. It operates under a tiered approach, again reference to the other assistance, such as internal moves, bespoke security advice, etc. Two-speed relocations.
This is out of date, though, at the time of the, which we're concerned with here, because presumably ATRIU left Kabul as part of the evacuation, if not before.
Yes, it was the current guidance, because I think this was probably in process
at
the time of the evacuation.
But is ATRIU continues to exist, but London-based?
I've printed off the updated guidance.
Oh, I see. Okay, well...
But this was the guidance that was in force at the time of the application, so I thought that would be most helpful to you, but we can give you the...
Okay, no, that's fine.
Yes, so there are new teams that are not based in Kabul, unsurprisingly.
Yeah.
It's the same sort of model. Again, at the bottom of that page, responsibility for assessing applications rests with the department which employed the locally employed staff.
Hang on. Processing the applications. What does that mean? Does that mean deciding whether the eligibility criteria are met? In that case, how does that fit in with ATRIU?
Sorry, where are you, my lord?
The bottom of the page, just where you were. You're saying responsibility for assessing applications rests with the department which employed the LES.
Yes.
But you've told us, I thought, that responsibility for assessing the applications was administered by a specialist team called ATRIU.
Yes.
Now, clearly, they're not quite, they mean different things, but I don't understand what the role of the ATRIU is and what the role of the department is.
Right. So I think the role of the ATRIU is inherent in its name, really. It is the threat and risk evaluation.
Yes, quite.
Yeah. And you'll recall we looked at one of the earlier pages about how the assessment of who is most at risk is intelligence-led. So it's not simply reliant upon what the locally employed member of staff says. There will be an assessment of...
Yes, they might, in the extreme case, be telling lies or they're exaggerating or whatever. But I'm sorry, I'm just asking, I don't think it's a difficult question. The form comes in.
Yes.
I haven't got to the form yet, but the form comes in. does Atrio decide whether they're eligible, or does the department which employed the LES decide whether they're eligible? They can't both. There's obviously some separate role for each, but it's not clear which is which.
No. My understanding, and I'll be told if I'm wrong, is that the department which employed the locally employed member of staff checks that all the details that have been given on the form are accurate. So worked here, they did this job, this was their staff number, etc.
Yes, I see, okay.
Atrio assesses whether, feeds into that, are they somebody who is at risk, are they a high priority for relocation?
So the department will look at it first to say we never have anyone with that name on our books, or we have, and that's absolutely true, and they did indeed work as a security guard or whatever. And then it's passed on to Atrio, who will say, oh yes, security guards at that base are incredibly at risk, or this was a low-level role that won't put them at any risk at all. Is that the way it goes?
That sounds a very logical order to do things in. I'm not sure it's apparent from this document.
Okay.
It seems pointless to be assessing the threat until
It may be
someone's
detail we don't
confirmed
need,
they
but
are.
as you're taking us through this form, I don't like not understanding it.
No.
Okay, so keep going. Where did you want to go next?
Okay. So, overleaf to page 53. Locally employed staff who are concerned for their safety should contact Atrio.
Yeah.
Okay. Third paragraph, further information including an online application form can be found on, and that's the application form we've seen
Page
at
5, yes.
Yep. There's a different system for locally employed staff applying from outside Afghanistan. You should know the ones from within would be prioritised. At the time of this guidance, which was 1st of September 2021, the expected timeline for relocation, for the relocation process to begin was 2 weeks for urgent cases. And
Now,
then,
hang on just 1 second. Have I got my chronology wrong? Surely the evacuation had already taken place on the 1st of September 2021.
yeah, sorry, that's what I was saying, my lord. Yes, I think Operation
So this was out of date when issued?
August. I think it had been written in the run-up to. It was
Yeah,
issued
sorry,
on the
I didn't
1st
pick
of
that
September.
up. Yeah, okay.
Yeah.
Keep going.
Yeah. We've got the updated guidance here for you, but that wasn't issued until
No, sorry.
April 2022. It's just that the locations and the names of the teams are different. The substances.
It couldn't matter less. I obviously appreciated that it got out of date quite quickly. I hadn't realised it was out of date at the very beginning. But nothing matters. Keep going.
So, by the bottom hole punch, the locally employed staff will be supported in the completion of an application form by Atrio, which will be considered by the Home Office
Sorry, where is this? Oh, I got it, yes.
and assessed in accordance with paragraphs 276BA1 and 276BS1 and following of the immigration rules. That is the form that I've just handed round.
So they do complete another form,
Yes.
and they're helped in that by the threat unit.
If they've been found to be eligible for assistance under ARAP. So I am told on instructions that the system now, because obviously as my lord said it was out of date at the time it was issued, is that the MOD, because it usually is the MOD, will send the applicant who is found to be eligible a secure link for them to download the form that we've just sent to you.
Okay, hang on 1 second. Which I've now forgotten where I put. I've got it.
So the ARAP form, you say, is a pre-visa application form. It's a screening form.
Yeah, exactly.
So I'm just writing once past screening. Is this right? MOD will send applicant secure link
Yes.
to download this form. Well, perhaps not download, but to complete the form online.
Access the form.
To
and-
access
yes.
the form, that's right. Right. Okay, I can't help saying it's astonishing. Did the judge have this form?
No, the judge didn't have it. There was evidence before the judge about what the process was, But she
It's
didn't.
very,
have
very difficult to understand processes without exhibits.
I completely agree, which is why I asked for forms.
Okay, right.
And I'm sorry, all I can say again about
No.
that is that this was a very tiny part of the case before the judge. But it
You've got to
may
allow
have
us to
been-
let off steam, but we let it pass.
So your case is quite simple. The application form means an application for the grant of leave. This was never an application form, which is only ever a pre-screening. And in any event, although I didn't realise until about 20 minutes ago, if I clicked the application form link on the guidance, I would never be given the option of an ARAP form. I'd only ever be given one of the
No.
ARAP forms.
No, yeah.
And the two questions, one, is that irrational, not having a form? And two, would you have to consider departing from the guidance? Those, you say, are the two real issues in the case, not the construction of version 1.
No, precisely. And I'm so sorry it's taken me such a long time to get there, but it
Well,
actually took me quite a long time to
we've
work
all
it out.
we've all put obstacles in your way,
No.
but I agree. I don't think the Secretary of State has helped herself by the way in which the material has been produced. But
No,
anyway,
no.
there we are. So just looking at this, in a sense, it's very much just who are you and a few basic pieces of information. Because once you are decided to be eligible, then you qualify under the scheme and indeed specifically under the immigration rules. So you just put in, as you say, who are you, passport, but you don't have to put a long thing about how I qualify because that bit has already been decided at the screening stage.
Precisely, yeah.
Hang on one second. Can we just see briefly the, if it's not taking you out of your way too much, the immigration rules into which this plugs?
Yes. Now, you've got some in the bundle, but it might be easier because I've just put them in a separate clip to work from the version sent through by the respondents yesterday evening or this morning. Is that? Do you have them conveniently to hand? Because otherwise, I'll find my page reference for where we've got.
What? Sorry. What did you want us to take to?
We've got them here for you.
What is it? Sorry.
The immigration rules.
Oh, immigration rules.
Unless
Well,
you
I've
have-
got it. I've got them. It's in my bundle. Or haven't I?
You have got. They've changed over time. So,
Have I got the right ones in the bundles? In which case, I'd rather look at them there than have another bit of paper.
I do think they are.
These are the ones in force at the time of the decision. The ones you've
Yes.
got in the bundle are the April ones.
Oh, I see.
Not
Okay.
these.
Right. And you said something about something the respondent sent through.
There's another copy of those as well. So if you've got the ones the respondent sent through,
I'm happy to. Well, I'm not sure I have. Let's have them.
But the pre-reads are almost pointless. I did spend a couple of days reading all the bundles from cover to cover and found it almost impossible really to work out what was happening, which I had those questions. I even went through chunks of the immigration rules. It's terribly dispiriting, having spent 2 days in an expedited case which you're told is important. It really is very dispiriting to realise you've read none of the relevant things, none of the rules in force. I can't tell you how much one's heart sinks, Miss Genevieve. Anyway, it's off my chest.
so sorry. I completely understand that, and I'd like to think that if I had been at work rather than off sick, it wouldn't have happened quite in that way. But I know it was all really, really unsatisfactory, and I just kept discovering this as I was trying to prepare for the hearing, and my heart was sinking, and I'm so sorry.
Well, that's very hard for us to go behind that. Thank you. We are where we are, which of course another complicated fact is not where the judge was.
Yeah.
And again, part of the explanation is that this was only a small part of the case before her. But in the end, of course, it's the part on which the claimants won. It's an object lesson.
Yes.
You need to prepare for every part of the case.
No, my lord's absolutely right.
Yeah. Okay. Well, let's now I've actually been given, thank you, 2 clips, both called pages 181 of 1350. They look to be identical.
I think you may just have 2 copies of
Good. Okay.
the same document.
I am going to call these. I need to put these in behind at the back of the supplementary, so they now become 138 and following. Right. So this is the bits of the rules, immigration rules. At what date?
October 2021. I think. Is that right? Yes. October 2021. Yes. 6th of October.
Okay, which bits do we need to see?
So probably 276BA1 at the bottom of the first page, or just by the bottom hole punch. So that records the need for prior entry clearance. And we've seen the process by which that prior entry clearance is obtained, namely an application under ARAP for an eligibility assessment by the employer and a risk assessment.
Sorry, you've gone too fast for me. Where's that eligibility assessment?
No, sorry, I was just saying that we've seen the process by which you get your prior entry clearance, which are the 2 forms, the eligibility assessment in the clip, that's the initial, my staff number is, I worked at X space, whatever, followed by, if you are found to be eligible, the visa application form, which we handed up.
Well, where, presumably, if this is logically written, you will get a definition of what the requirements for entry clearance as a relevant Afghan citizen are.
Yes.
Where is that?
They're very complex.
Well, where are they?
They start at 276B B1 at the bottom
Well,
of that
strictly
page.
speaking, that's not right. That's the definition of a relevant Afghan citizen.
Okay.
Sorry, there are 2 concepts. One, what is a relevant Afghan citizen, which is at 276 BB1. And secondly, what are the requirements for entry clearance as a relevant?
Yes. So,
But maybe they are all wrapped up in the definition. Yes, I see. So you say that is all, despite what I said, which is perhaps being over pernickety.
Isn't it, in 276 BC1, that if you meet the definition, you'll get it unless you fall for refusal under Part 9.
Where does it say that?
It's the foot of page 182 under the heading Refusal of Entry Clearance as a Relevant Afghan Citizen.
Yes, remind me what Part 9 of the rules is.
that's general grounds,
Yes.
character, criminal convictions,
Yeah,
etc.
right.
You're going to hate me for asking this question, Mr. Untitled. Do you know the form that's sent by Secure Link from the MOD when they've assessed you? That visa application form is not publicly available, isn't it? I can't go on to the room, type anything in saying relevant Afghan citizen or Rule 276BB, and this form will pop up.
No.
So a person could never fill that out.
No, that's absolutely right. That form is not publicly available.
Gosh.
It's the same as the, I don't know if you picked up in your reading of documents that are only peripherally relevant in the bundle, but there's an example form that was used by the
Well, for the football team,
football.
yeah.
Exactly.
That was
Yeah,
the Syrian
exactly.
one, which they adapted.
Yes, yeah, and that's the same, not available publicly because somebody has to go through a screening process first and be identified as eligible to apply, and then they get access to the form.
Because were it not for the fact that you can't get it off your computer will deny it exists. The form that's most closely analogous to your circumstances, if you're Judge S or Judge AZ, is this form actually, isn't it? Of all the forms, of all the visa application forms that's the most closely related to your circumstances, it's the one you don't let them have.
Yes, but yes.
Well, it doesn't ask for any information really, apart from
Well, extra information. If you need to add more information about your application, but we're not able to, you can write it here.
Yeah.
That sounds awfully like.
Could we just understand it? Yeah, another rant coming. It's shockingly put together. So you've got all these sub-paras, little Roman 1, little Roman A, little Roman, all over the place. You can't understand how they all fit together. But I think, and really whoever is in charge of putting these things online must try and make them more accessible. We've been saying this certainly since I've been in this court. Nothing seems to happen. I pity anyone trying to understand this. However, 276 BB11, BB Little Roman 1 and, so you've got to have that. You've got to be over 18, you've got to have that. If applying on the basis of redundancy, you don't have to be applying on the basis of redundancy, because the next one is or. For if applying on the basis of the relocation assistance scheme, that's the R1, isn't it?
Yes, it is.
And then there's a series of requirements, A to E. So yes, A basically says you have got to have been employed by one of those three departments. And you have got to have submitted an application. That's the one that my lord was just referring to, that's sent to you if you get through the screening.
Yes.
Why?
Well, is that right?
I'm not
And
sure that's right. And might be the...
Or submits what application? Well, let's just go on, because that may stress it right. C qualifies under one of the following categories. Is it your position that, and then, sorry, D is really a subset of C2, so isn't a separate one.
Yes.
And then E has been determined by the Secretary of State as being in need of relocation to the UK. How does that fit? How does those requirements, how do they map onto the process that we've just seen? In particular, what is the application that has to be submitted? To who determines qualification under C? And E, which seems to be separate from C, has been determined by the Secretary of State as being in need of relocation.
Yes. My
Perhaps you can't help.
understanding is
Yes.
that it was put in the immigration rules because it was thought sensible to formalise it and because they are criteria. But the criteria are applied by the MOD stroke FCDO stroke HREU in assessing the application.
So you really say that C to E are what is assessed by the MOD.
Yes, and the
And is
Secretary
the
of State...
application then the ARAP form or the secure link form? Which is it?
I'm not sure, and I'll take instructions and check on that. But I think it's the reality is that the Home Office only get involved once this form has been completed, and they get involved to do the security and biometrics checks.
Yeah.
But the substance of the entire thing, employment, risk, etc., is assessed by the government departments involved who were involved in Afghanistan.
That's certainly, you explained that very clearly. It all makes sense, unless Ms. Knight persuades me separately. So that's obviously how it works.
Yes.
I'm just trying to see how that maps onto these rules. And that and you have, I think, answered most of that by saying C to E is the process that's done by the MOD and ATREU.
Yes.
what we call loosely the screening process, though it might be rather more than that, it's actually really the substantive decision. However, or subject to biometrics and security, and then the application must, in the context of the immigration rules, be the one I would have thought that they are asked to complete once they pass screening.
I think that's probably
that
right.
that's the only way you can make sense of it. It's a rather odd application because all the 9/10 of what is needed for the application to succeed has been passed in order to let you make it in the first place.
Yes.
But it works.
Yes. Yes. Yeah. And unless I'm told on instructions that that's wrong, that was my understanding, certainly.
Nobody is shaking their heads, but nobody's going so far as to nod, so perhaps they haven't worked it out before either.
But say you were a person whose neighbour had gone through this, and she said to you, in fact, Ms. Janovetti, what you do is you go through the ARAP form, then they'll send you the other form, and you think to yourself, well, the most closely analogous form is the secure link form. The only way, if you're an Afghan, that you can get the secure link form is by filling in the ARAP form first, bizarrely. So if this form is a visa application form, and it is the one that is most closely analogous, and if you can only get it, even though you don't meet the criteria, by sending in something to the MOD, because that's the only way you get the form in the first place, how are they meant to use the form that is the most closely analogous visa application form?
Yeah. I think the short answer to that is that the process can only work efficiently and effectively if the ARAP route is limited to people who are eligible because they are locally employed staff or the tiny handful of special cases. And that's the way it was designed.
It is a visa application form at the end of the day. And it's the most closely analogous, but you're not letting people access it.
And I absolutely hear what my Lord says.
Yeah,
but
and you
when
just
I
say that's the way it is.
Yeah. I mean, I think all the visa application forms allow you to enter your personal information, passport number, sex, date of birth, etc., etc., etc. What you really need, as my Lord put to me a moment ago, is a box for extra information.
Which is in this form.
It's in this form, but it's also in the other forms. So really, the complaint is that the title of other forms are not appropriate. This one's entitled Afghan Locally Employed Staff Ex Gratia Scheme 1. The forms that we're saying, the Secretary of State says, should be used are forms that say something like visit visa.
Yeah, but if you want the most closely analogous one, this might be the most closely analogous one, though.
But they're not going to be criticised for not using it because it's not accessible to them. And they're not going to be criticised for using a visa application, a visitor visa application form, because that is accessible. And so long as there is the wherewithal, in my respectful submission, to fill into the form the key information that's needed in terms of identification information and the substance of the reasons that leave outside the rules is being sought, the form is usable even if it might not seem logically the closest form, visa application form. Which is, I suppose, will depend on the circumstances, won't it?
I'm trying to find one of the other forms now. The visa one that you've seen.
Look, let's have a look. It is now a good time as any to look at the one form we have got. I can't remember where it is now.
Yeah, that's what I'm trying to find.
It's in the clip, isn't it? Or is it the one that was used for the football team?
Well, there's one after, in the bundle, after the one for the football team is the one that you say you should use.
There's
So
a
that's
visit
where
visa one in the... Yeah.
It's a
In the
visit
bundle
visa
there's
one.
a visit visa.
Where is it?
And
Or you're about to hand it up?
I don't-
No, it's one
Then-
to one.
And then we sent through a couple of days ago the family one.
Okay.
So I'm happy to work.
Well,
with
I would like to have everything there is, but then you can teach us which one you want us to look at. But what I think both my lord, I'm sure my lady, and I want is now to be taken through at least one of the candidate forms to see what sort of information, what sort of questions you have to answer.
Well, I've been looking at the one at 121
121
of the second supplementary bundle. That's the one that we've been referred to in the past.
You happy
And
for us
that
to
comes
look at that
after
one
the
first?
football team one. The football team one was at 118, but they were already in Pakistan, and they adapted the Syria one. And then at 121 there was another form, and I just couldn't see a box saying extra information, but it's probably...
Well, look, now we've been handed these things up, let's not lose discipline. Let's put, before we do anything more, let's put these ones at the back of the supplementary bundle where they will be. I haven't, I'm afraid, numbered through the stuff we were just sent, so give me a moment. On the basis I don't number the blank pages, this will be the first page, 1 of 13 that we've just been handed up, is I'm calling 145. And what is this, Ms. Giovanetti?
So this is a family application. You see just above the top hole punch, type of visa application, partner is someone in the UK with refugee leave or with humanitarian protection.
Okay, yes, right. And now that, yes, I see. Well, we can certainly look at that one if it will add anything, but why don't we do as my lord suggests and look at the one we have already, which is 121 in the same bundle. Is it one?
Yeah, 121 visitor visa.
Which is visitor visa, yes.
That's the one that's been suggested below.
Yes.
So this is the standard visitor visa, and this was the form that was used by JZ, for example.
Can I just pause as we're coming up to the short adjournment? It's probably not necessary, but I think I would feel more comfortable if we had the key documents about JZ, because he's been referred to a lot in the correspondence. I don't know what there are, but I think, as I understand, there was a permission decision by Mr. Justice Kerr. If someone could put that together over lunch, yeah. I think it would be useful to have.
There was a really reasonably concise and informative judgment on an interim relief application from Mrs. Justice Leven, which I think would probably give you the key facts.
Okay, let that be very helpful.
That here at court, if my lord would like it.
Right. Well, will you give it to us when we rise? Right. We were looking. This is the one used by JZ. It's the visitor visa.
We don't accept that it was used by JZ, so I think we need to clarify.
Oh, right.
This form in particular,
Yes.
or any visit form?
Any visit visa form.
Okay. So, well,
Ultimately, it perhaps doesn't matter. It could have been used by him, but it wasn't, whether or not it was.
Oh, so the extra information is on page 128.
yes.
So I'm being slow, but just running through it.
Oh, yes, there is a box.
Email address, what's the main reason for your visits? I suppose you could fill that in, it's rather odd. Yes, well, I see travel information, personal information.
The date you plan to leave the UK, you'd have to put in, I don't plan to leave the UK.
Yes, exactly.
Or not applicable.
Or it might be that somebody says uncertain, because they may want to go back to Afghanistan if the situation improves, but they can fill in whatever is most appropriate for them to fill in.
The first thing they've got to try to do, what is the main reason for your visit to the UK? Well, it's not a visit, it's a stay until I can get back. I mean,
Indefinite.
but you say you could fit it in.
You could fill it in, and you could say, I am in fear of the
my
Taliban.
life.
Exactly, exactly.
But yes, I see, as my lady's sensibly jumped ahead, really the meat of your application would have to be in the extra information.
Up 128.
Yes.
Yes.
Okay, well that's been very helpful. Shall we just do the same exercise with family application, which you've just handed up? Were these in front of the judge?
No. The one at page 128. Yeah, the visit visa in the bundle was before the judge.
Yes, I see.
It's just in I think we produced this because my lord asked us for.
No, I'm very grateful to you for doing it.
But I think the process is, the analysis of the form is probably very much the same.
Yes.
And the additional
It's
information.
9 of 13 is the additional information.
Yeah.
Yeah.
And you'll see.
So pretty well, is this the position that pretty well any form will have a whole lot of questions which are standard and no problem to fill in, other ones which are specific to that form of application, which you'd have to work your way around and either say not applicable or something, and then additional information, which is where on your route you'd have to say, actually, none of the above is really relevant to me because this is why I'm applying, because it's the nearest available.
Yes.
Okay, thank you. Well, that's.
I think what may be
puts flesh
helpful
on the
about this
bones.
form, and it's probably self-evident from the other form as well, but you can see from pages 9 and 10 of 13 that the additional information box will expand, and you can actually fill in a lot of it.
Yes.
there.
No, I'd assumed that there wasn't. Nobody suggested there was a limit. And the just on the where's the bit about biometrics on either or both of these forms?
I don't think you can see it on either of these forms. As Miss Terenius explained, when you filled in all the form and you then have to upload your documents and then you get the box to tick.
Oh, I see. So, but the biometrics. Have we got what that looks like?
We have an annex to Janet Gordon-Smith's witness statement, and it was before the judge as well, in, I think, the first supplementary bundle. In many bundles.
Sorry. Is that 304?
It is. My lord.
Yeah, the forms at the back.
At 314, Exhibit JGS1.
And do I understand that if you didn't fill out that box at the relevant time, the application was not treated as valid in the sense that they did not regard it as a completed application, or that they wouldn't process it? What happens if you didn't fill out that box?
Okay, so if you look at 314 and 315,
Yeah.
315 now has in parentheses, I've identified the country where I'll provide my biometrics, or I am unable to provide my biometrics at any location. The bit in parentheses didn't used to be there on the old
Yeah, that's the
form.
new form, yeah.
And you couldn't actually upload the form, as I understand it. Mr. Nike, I'm sure, will tell me if she disagrees or if this is contentious, but I think we've all reached the point where everybody agrees that unless you ticked the box confirming that you could go and register your biometrics, the form would not upload, so you couldn't.
Computer say no.
Sorry?
The computer just say no. Computer says no, you can't enter your form
Exactly.
without.
Yes. Yeah.
You had to say something that was untrue.
Yes. And that was the flaw in the form which the Secretary of State accepts was a flaw in the form or a defect in the form.
So they couldn't fill out a visa application form then. So they'd have to write to you and say, I'm terribly sorry, but computer has said no. We'll have to do it on paper.
Yeah. That was the original position. The Secretary of State gave this assurance, as you may have seen in the history of the cases, that even if they ticked the box, as long
Even
as
if
they
they
had
lied, the Secretary of State wouldn't hold the fact that we required them to lie against them.
Yeah.
putting it
And then the
pejoratively.
form was redesigned, I think, as
Many
quickly
months
as they
later.
could. Well,
I mean, it is a pejorative way of putting it, because suppose you write at the same time saying, I've ticked this box, but I don't want you to be misled. I don't think any jury in the country would regard that as a lie, but they would still regard it as very unsatisfactory.
it was,
And I can see why people would be nervous about doing it.
yes, it was patently unsatisfactory, and I'm not going to try and sort of make submissions to the contrary. And in fact, against myself, I ought to make the point, I suppose, that it wouldn't be limited to Afghanistan.
No,
for a
it'd be-
problem. There'll be other countries.
It would be other places,
Yeah.
actually. Think of coronavirus when things weren't operating.
Yes,
I mean, you might not be able to go anywhere because they might have closed.
yes. I think quite a lot of them did close temporarily.
But the lie, to use the pejorative term for convenience, is the phrase, the country where I will provide my biometrics. Because the claimant must always have thought it likely, I appreciate likely isn't the same as certain, that if she were able to leave Afghanistan, if she wasn't, the whole thing is academic anyway, but if she were able to leave Afghanistan, it would most likely be to Pakistan. I appreciate you can get out to other countries, but that's the most obvious country. In which case, she should well, going back to 314, enter the country where you'd like to provide your biometrics. Well, the answer is I would like to provide them in Pakistan. That wouldn't have been a problem.
What if she
Where does the lie comes in? Because the next box says I've identified the country where I will provide my biometrics. Is it the change between like to and will that's the problem?
I think it didn't have, the first box didn't have, or I am unable to provide my biometrics at any location. So if you tick the first box now, you've identified the country, or you're confirming that you are unable to.
But in a sense, even that wouldn't be a lie. I mean, she's unable to now. But she, in the only circumstances where it matters, namely that she gets out of Afghanistan, she will provide it in Islamabad.
Yes, I think that's right. This is the current form. I think the old form, part of the process.
Oh, I see. I thought
was,
have we got the old form?
I don't think we have. No.
Is it unavailable?
There was a copy of it, I think, in J's case. I suspect it is unavailable. You may get the dilemma set out in the judgments in JZ's case.
Could you put in the United Kingdom? Or would it refuse the form?
Don't know. Could find out.
Because I understand it, this is your understanding as well, I imagine, the claimant is never saying, I want, what you may inadvertently have said, but her true position can't be, I won't ever provide biometrics, nor even, I will only provide them when I get to the UK, but that I will provide them at an overseas VAC, but I can't tell you which at the moment, because I haven't got out yet, and I don't know where I get out to.
My recollection.
That's right, is it?
My recollection, and I'll tell you on instructions if I'm wrong, but my clear recollection from time that JZ was being prepared, and I wasn't involved in that case at the material time, but I did read into it, was that the form asked you to tick the box that said, I confirm that I can attend at X visa application centre to register my biometrics.
It must be, yes, it must be something like that, because this language, it's not just with respect to the words, or I'm unable to provide. I don't think it would be much of a lie if the rest was still there. But, if you can't provide the form in its original form, I would at least like the authoritative evidence saying what it said, which was, that's the basis on which the judge decided the case, after all.
Yes. It's
maybe it's in Ms. Terenius's witness statement or somewhere, but there must be a summary of it.
We will get that.
All these counsel in court, some of them will know where it is.
Yeah. I think in JZ the solicitors provided screenshots of the page.
Well, that would be very useful, but evidence ought to be in this case somewhere.
Yes.
Because
But there isn't.
the judge put you down on the fact, this is her alternative reason, that you couldn't comply with, you couldn't honestly sign the form of words. So she must have known what the form of words was. And I don't, but if it's in the judgment, I can't remember where it is. And if it's not in the judgment, we'll get that. Right. How are we doing? We're covering a lot of ground in a different order from which you plan to cover it, no doubt, Ms. Giovanetti, but you've been in this court enough to know that's what tends to happen.
Well, I'm extremely grateful to the court for its patience and tolerance over the other
It's an important case. We've got to get to the right answer, despite the obstacles in our way. Yes. Now, do you just want to regroup to tell us where you want to go next, and we'll decide whether we will rise early or...
Yes, I think what I had planned to do next was go through the history of the two cases very briefly, but in fact we started off by looking at some of the key correspondence in S's case, and it's in materially the same terms in AZ.
Yes.
So I should be able to do that, I think, relatively briefly. I was going to very briefly give you an overview of what's been referred to as Operation Pitting LOTR and the ACRS.
You don't need to do that.
They are the other Afghan specific routes. But they weren't, I mean, neither...
The point, I don't think anyone is suggesting... The claimant's case on substance, if I've got this right, which is not before us, claimant's case on substance is, OK, Pitting LOTR as such has ended, but it is unfair and inconsistent not to allow leave to enter to people who would have qualified under Pitting LOTR if they'd had the chance. That's roughly it, isn't it, Ms. Naik?
And that's
well, that's all we need to know. They may be right, they may be wrong, but we don't need to... I think I do understand Pitting LOTR because I've done my pre-reading, but... OK, ignore that bit. Yes, what else are you going to do?
Now. And then I was just going to briefly take you to what we say are the errors in the judge's reasoning.
Yeah. Well, I don't promise that we will keep quiet after lunch, because if there's things we need to get to the bottom of, we will go on till we do. But with a bit of luck, we will be sailing into clearer waters, and you might well then be finished by 2:30. Yes. We've already gone on longer than the estimate, but we all understand the reasons why. We will, if necessary, go on for the rest of the afternoon. Frankly, Ms. Naik, now we've done all this stuff, the actual, I don't think you'll need to go over any of it unless any of it is wrong. Yes. And you can just focus your submissions on actually saying why the judge was right. So I suspect you can be pretty brief.
Yes, the only thing I wanted to particularly emphasise was how a judge like AZ and S could get into the ARAP, to the LOTR.
Yeah, well, we won't stop you saying anything you need to say. We were hoping, for obvious reasons, to give you a decision, if not today, tomorrow. Not impossible. We might even be able to give you a decision with reasons, so that might be a bit heroic. It depends how it goes. So I am anxious we don't waste a lot of time this afternoon that could be used thinking and writing. Yeah. But of course, bear that in mind. But in the end, we'd rather hear what we'd rather hear.
I think I can be very brief this afternoon. Subject to questions from the court.
Right, just give me one moment when I assemble my lunchtime leave.
Could we hand up the judgment to Mrs. Justice?
Oh, yes, do.
JZ.
Yes, that could be quite useful.
JZ has also got a pending decision, a challenge before Mrs. Justice Hill on his own ARAP decision, and a separate pending challenge to his LOTR.
I don't think it makes any difference, but just so that you know, my recollection is that Mr. Justice Carr refused permission on the interpretation of the ARAP criteria granted on LOTR, and I was the Court of Appeal judge that refused permission on the first ground, but I don't think I said anything about the LOTR
No.
grant, and if I did, I've
No.
safely forgotten it now.
Particularly, it was only in connection with the work, the interpretation of
Yes,
working
the
on
proper
time.
interpretation of
We do
that,
have
yeah.
that order,
But you know that I have looked at that case, just in
Yes.
case, yeah.
Thank you both very much. 2 o'clock.